I can, yes.
Yeah, all I want to say is, this went on for 6 years, and we were just trying to rent to somebody wanting to buy the house. These people are obviously professional tenants, and we were denied an eviction. Uh, we were trying to get them out for a year and a half before they called the Board of Health. So, I mean, we had to deal with all of this. Wouldn't it have been easier just to give us the eviction?
Hey, thank
Avoid
you,
this
Mr.
whole
Velard.
mess.
Yeah, thank you, sir,
All
for your
right.
comments. Okay.
Hey,
Good
bud.
morning, Derek Eagle. Can you put your camera on and unmute yourself? The judge is getting ready to enter. Are we waiting for anyone else?
We're waiting for Mr. Aubert. I'll just, do you mind if I just call him to make sure? I just sent him a text a bit ago saying you logging in question mark. I know he had another hearing at 9 and I believe in another court. So let me just give him a buzz, Amy, before we get moving.
Okay.
Mm. Amy, he's logging in right now, so give him a minute or two.
See if it goes back to him. Lorna, would you get me a glass of ice water, please?
There he is. Hey, Bob.
Hey, sorry about that.
No worries. At least we got you now.
Thank you. Is there paper in there? An orange pen over there that works. Yep.
On the record, 19 CV 334 Orange Board of Health versus Eagle et al. And 21 CV 772 Town of Orange versus Eagle et al.
Well, thank you, Madam Clerk. Good morning, all. Welcome back to Housing Court. This is Judge Fields. Happy Friday. Hi. So why don't we have introductions? Who's here, starting with Town Council?
Donna McNichol for the Town of Orange.
All right. And who did you have with you today, Attorney McNichol?
Matt Fortier, the health agent for the Board of Health.
Okay. Thank you. Yep, I got him. All right. And property, well, receiver?
Good morning, Your Honor. Catherine Higgins-Shaff on behalf of Pioneer Valley Redevelopers LLC. With me is Robert Aubert, the manager.
Morning, Your Honor.
Good morning. Occupant?
Derek and Crystal Eagles.
Thank you, Mr. Eagles. And the Velard, starting with Miss Velard.
That's me, Barbara Velard. My
Good
daughter,
morning.
Mark.
I'm
Good
sorry.
morning.
Okay, good morning. And your son, Mark?
That's me.
Okay. And then who's next to you, Miss Villard? Ah,
That's my daughter, Marna.
oh, Marna. Okay. All right, folks. Thank you. We also have back from Pennsylvania, Attorney Mulcahy.
That's right, Your Honor. I'm just sort of listening in right now, if needed. If not, I will not be uttering a word.
It's good to have you because I remember the case, of course, very well. And
Yes.
there's still a voice in my head asking who owns this place, and that's an important question.
There we go.
For this judge. All right, Attorney McNichol, you get to tell us where we're at. This is an interim review of a receivership and maybe some motions. So what's on for today?
Yes, that's correct, Your Honor. It's the review of the receivership's first report and rehabilitation plan. The Town of Orange Board of Health and myself have reviewed the plan. It's, in our estimation, reasonable and adequately covers the repairs that are necessary to 89 West Orange Street, and we would ask the court to approve the receiver's plan.
Okay, so why don't we hear Attorney Higginshea? Is there a motion for approval?
So, Your Honor, I filed it as a first report and rehabilitation plan. I served it on the parties who might have interest. I didn't formally call it a motion, but I believe that's what we're here on.
All right, and the return of service includes notice to the credit union?
Correct. I sent it by mail to the credit union, and because of the snail mailish sense that we're all in, I also emailed it as well as first class mail to Attorney McNichol, Attorney Mulcahy, and the Velards, I believe.
Okay, so I have a concern that they're not here, but that concern goes either way on the needle once I figure out, or we all figure out, if they have any interest in this asset or ownership of this asset, given the bankruptcy proceedings. Why don't we hear the update from the receiver's side and the request for rehabilitation plan approval, and hear from everybody else as well.
So, Your Honor, I think I'll let Mr. Aubert walk you through. As you may recall, last time we were here, there was a scheduled inspection of the property, which Mr. Aubert has completed, and I believe he walked through with the health agent. And Mr. Aubert, why don't you unmute? You probably are the best person to talk about the condition and what your plan is.
Yes, good morning, everyone. Your Honor, after our scheduled walk through the property with the health agent, we took action based on Your Honor's order from the last hearing. We have developed a plan to get electric heaters installed in the building. Actually, I have the electrician actually there today as we speak, working at the property. We're waiting to meet with Eversource. I'm sorry, actually, I believe it's National Grid at this property. We're waiting to meet with National Grid's engineer on Tuesday to just make sure the location we've selected on the exterior of the building for a new electric service is within their parameters and approved by them. And then we have all the equipment ready to install a new electric service on the property. Pending their approval on Tuesday, I believe that work will start Wednesday of next week. So the heaters will be all installed, ready to be turned on. Once the new service is put on the building, it'll sort of all come together probably by the end of next week.
Thank you for the quick work.
We did have to clean out the basement a bit in order to be able to actually work down there. So we did, ask the tenant occupant to sort of secure their belongings, and we discarded everything else in the basement so that we could move around and work down there.
And I think there was, Your Honor, some other work that Mr. Aubert has noted in his report, including some flooring in the kitchen. It looks like they're going to have to do a little more assessment on the plumbing, but it seems as though the bulk of this is electrical work that needs to be done for the heating system.
For the emergency part of the order, I think in review with the health agent, we developed and established comprehensive redevelopment plan and rehab plan. Some other items in there that were brought up by the Board of Health. Some issues with the kitchen floor, probably needs a new subfloor and a new floor installed. That the side porch is questionable, probably needs a replacement. Some siding issues, some rotten trim issues, siding exposed, torn off the building. Most of the work is exterior with a little bit on the interior of the house, a couple safety features, some handrails, but that's the predominant work that needs to be done. I think we outlined in the rehab plan.
Okay, so Attorney Higgins-Shea, I need you to sort of bring it all home with the ask of the court with the total dollar figure, including insurance, legal, anticipated legal costs, and receivership.
Yep. So, Your Honor, I did the math, and the high end is I believe about $104,000. I didn't calculate the low end of it, but because he did put in a range on some of those. Frankly, that's helpful. But I believe the ask is 104, and that includes not only just the repair costs, but it includes legal costs, it includes insurance, it includes some of the receiver's own costs, which would be management, snow removal, lawn care, if this made its way all the way through those seasons, Your Honor, bookkeeping, checking on the property, checking on the on the job in progress. It also includes a cost if this was to be a lien that is foreclosed upon. So the costs of that are included as an estimate as well.
Thank you, Attorney Higgins-Shea. Before I hear from others, what's the anticipated completion date, Mr. Aubert?
I would put this project 4 months, about 4.5 months out to be completely wrapped up, I think, and go through the process.
His report estimates, Your Honor, the end of April. I suggest probably May is probably the safer, right, Mr. Aubert?
Yeah, I would agree.
Completion by May 31st, I'll put in. All right. Why don't we hear? Yeah.
I'm sorry, if I could just add, I don't know if my attorney had mentioned it or not, but we did want to try to formally establish tenancy at will with the occupant, just for all points of reference. Kate, I'd let you take that for me.
Oh, I think, well, any receivership order allows Mr. Aubert to collect rent. And I think that's where he was going with that. And I believe Mr. Eagles has told him what he believes the last monthly rent amount was. And maybe he can confirm that, but maybe to get that back on track as well, that would be helpful in keeping the lien a bit lower.
Folks, the order, if it's issued, will include a lot of language about how to handle that, including how to resolve disputes around it. Always by nature of a receivership, the rent is adjustable either by negotiated agreement or court order. But thank you. I understand that'll be in there. Why don't I hear from anybody else who wishes to address the court, starting with the town?
Your Honor, the only thing that I would point out is the insurance certificate is for the building, and it doesn't appear to be any liability insurance, and I don't know whether that should be addressed at this time, given there's a tenant in the property.
Yep, Attorney Higgins-Shea?
I'll let Mr. Aubert speak to it.
Yeah, we have full liability coverage. I might just have been missed, but I can make sure that we provide that.
Thank you.
Thank you.
Anything else other than support for it, Attorney McNichol?
No, Your Honor.
Okay. Anybody else wish to address the court? If so, raise your hand.
Yeah, all I want to say is, this went on for 6 years, and we were just trying to rent to somebody wanting to buy the house. These people are obviously professional tenants, and we were denied an eviction. We were trying to get them out for 1.5 years before they called the Board of Health. So, we had to deal with all of this. Wouldn't it have been easier just to give us the eviction? Avoid this whole mess.
Yeah, thank you, sir, for your comments. Okay, Folks, this all looks like it's in good order. There's no opposition, and sounds like for good reason. I just want to pause for a moment and ask counsel who are in this case, but of course, if Mr. McKay, Attorney McKay, has some thoughts. I think it's vital. I would think it's vital for the receiver. I think it's vital for the town to know who owns this property. And I appreciate we heard from Attorney Mulcahy and before him his client, Ms. Velard, that there's a belief that there's been a discharge of the property. I think it's a discharge, if you want to use it as a verb, it's discharge to somebody, and I'm guessing it's the bank. And if the bank says, I don't want it, I'm not sure that's legally sufficient. So, Attorney McNichol, what do you think?
Your Honor, the only thing I have to go by is the registry records, and it's clearly still in the Velard's name. And I've talked to Attorney Mulcahy at length. I've talked to the Workers' Credit Union representative, and Workers' Credit claims they have no responsibility for it and have no interest in this property. Whether or not legally the bankruptcy court, if the Velards are discharged, can then automatically transfer it to the holder of the mortgage and note. I legally do not know. I mean, I can certainly consult a bankruptcy attorney and see what I can find out if the court directs me to do that. But right now, the Velards are the owners of record, and that's, of course, what we've been going by.
All right. Before I hear from the other attorneys, so far, one notion here is to reflect that the Registry of Deeds still reflects the Velards as owners, and we will go forward with that until moved in a different direction by motion, either by the Velards if they think it's an important factor to be heard on, and we'll keep sending notice to the bank, to the first mortgagee. With that said,
Your Honor,
yeah.
This is Mr. Mulcahy.
All right, Attorney McKay, are you able to show yourself visually or no?
I believe I can.
Yeah, I didn't know you wanted because I couldn't see you. What would you like to say, sir?
Regarding the point about the discharge and the bankruptcy laws, during the course of the bankruptcy, the Velards not only go through, have their debts discharged, the property itself is released to the bank. All right. It is the bank, for whatever reason, saying, oh, we have no responsibility for it. It's not really a true statement. There is nothing that I have looked at in Massachusetts law that forces the bank to foreclose upon the property. By bankruptcy law, however, that the property has been released back to them. They don't want to take it for insurance reasons, it might be, or the fact is they don't have an REO department that can resell it themselves. And they're saying, oh, no, we're washing our hands of this. Normally in situations, and I don't know Massachusetts law in that, I'm not a Massachusetts attorney, and I appreciate, Judge Fields, your kindness in allowing me to speak on a record here. In other cases, when I worked as in-house counsel for Aquin, one of the larger mortgage receivers, and when we had that, if we decided or the banks decided not to take the property, there were usually mechanisms that allowed the townships to declare it by waste, like a waste statute, that they could take over the ownership issues. I know there are waste statutes in some different precincts in Massachusetts because I had a case literally that was out on the Cape. It had to do specifically with that kind of an issue where a bank didn't want to take it, where the town took it over. So I don't know if the Springfield area has anything like that, but I see that Donna wants to say something. Let me just finish here quick fast. In that, normally, if it's not there, my concern, and I know Mr. O'Bear, I appreciate the fact, my concern was liability insurance. If we're going to do this and the Velards are going to be record owners pursuant to, that they're just on the deed until the receiver takes care of or leaves the property whatever way he can, I want to make sure the Velards are not going to be held liable for if somebody walks on the property, a slip and fall kind of thing, that they're not going to be issued that kind of liability, or if the building collapses. I know these talked about structural things. I don't want them to be in a position, and I'm just making it clear on a record, is that according to the bank report, they cannot be held responsible for any of that sort of thing.
All right, Attorney Mulcahy, thank you so much. Attorney McNichol, before we come back to you, Attorney Higgins-Shea, do you want to weigh in at all?
So I'm waiting for my title exam to come back, but I'm assuming my title exam is going to come back with substantially what Attorney McNichol said, which is we go off of we're a record notice state, and record notice, and I did a title rundown before I filed the report, shows that the debt to Workers Credit Union hasn't been discharged, that the Velards still have the ownership interest. I'll also say, with respect to the liability insurance, and Mr. Aubert can provide whatever satisfies everyone here, but by statute, by the receivership statute, the receiver's liability is limited to the asset. So the asset here is 89 West Main Street. I mean, that's the only thing someone could come after. But just for the sake of saying it, putting it out there that it's great to have liability insurance, but it's limited to what we got here. So I mean, my rundown showed exactly what Attorney McNichol said. Unless something else is put on record, who's to know that this bankruptcy issue is out there, I guess.
Yep. Attorney McNichol, did you want to say something else?
Yeah, just for the record, Your Honor, I mean, the town of Orange is a small community in Western Mass, and a poor community at that. They have absolutely no ability to take over and manage a property of this nature. So that's just not an option. So I need to put that on the record. Obviously, once Mr. Aubert gets the repairs done and this property's auctioned, that will resolve the title problem and resolve all this. And if the only thing that the Velards are subject to right now is notice and knowing what's going on in this court relative to that property, then I don't think that's such a burden. I think that there is the issue of liability and whether something can be done about that to protect them, given everything going on. I think proceeding with as much haste as we can is really how this problem's going to be resolved.
Attorney McNichol's right. I mean, if every time I've had something on a title that is questionable or whatnot, a receiver's auction or sale wipes out everything behind it, and that would resolve everyone's concerns. But I mean, until that comes, I'm not comfortable not serving notice on the Velards or Workers Credit Union or the town.
Oh, absolutely.
Your Honor, just for the record, I would also point out this house is assessed at $109,000. We've now got the receiver's report that it's $104,000 to bring it up to code.
Yep.
So the truth of the matter, that's the truth of the matter with this property, and understandably why the Velards don't want it. Workers Credit doesn't want it. The town doesn't want it. And so I'm wondering if there's some way for the receiver to get a rider or something in this case that would be for liability that he could charge, obviously, on his receivership that may address that issue. And I just don't have an answer to that.
Attorney Higgins-Shea, what about that notion that you'll investigate the possibility and the cost, if it is possible, for the receiver to have a rider of some sort for additional liability beyond the value of the asset? This is not, I'll be candid, the first order of business for me is not to protect the Velards or the bank. It's to protect the person should they get seriously hurt and be limited in their collection because we haven't figured this part out or covered it. If I was the bank, if I was the Velards, I'd be real nervous about this. And the law of this case right now, folks, is as Attorney McNichols and Attorney Higgins-Shea said, and that is that the Velards are the record owner. I'll be candid again. I think Mulcahy's spot on from my experience with bankruptcy proceedings. I think I've said this since the first hearing. I think when it got discharged to the bank. And I think his assessment about the bank's approach on it, even if it's not knowing, is at least what he thinks is what I think. They want to avoid it. They don't want to touch it. but maybe it's also in good faith belief that they don't own it. So, Attorney Mulcahy, Miss Velard, you have an interest here to move the law of the case into a different direction. Hold on, Miss Velard, a different direction, which is that the law of the case not be that you're still the owners, but that is the law of the case in Massachusetts, the record owner. And if you can change what's at the Registry of Deeds, if you can convince me otherwise because of bankruptcy law, if you can convince the bank otherwise because of bankruptcy law. But in the meantime, Attorney Higgins-Shea is a practical solution. I like what Attorney McNichol suggested, if it's possible, and whatever the costs are, to let us know. And if we are okay with it, they will be added. Hopefully they don't eat up the remainder of the little bit that's left over our 104. But it may be assessed at 109, but after Aubert touches it, it could be worth $1 million, folks.
Could be turned to gold.
Oh, you're too kind, Your Honor. You're too kind.
Ms. Velard, thank you for your patience. What do you want to say, ma'am? Wait. You have to unmute before you speak. Thank you.
Okay. I had thought this meeting was to transfer the ownership to the Aubert, the receivership. But wouldn't it be in everyone's best interest if the Eagles moved out of the house, and then that way no one would really be liable for their injuries?
Amen.
All right, folks.
Really?
The receivership activity that's at the heart of this case is by way of a statute. No surprise. There's a law in Massachusetts that allows for appointment of receiverships, and it doesn't transfer the ownership. It transfers a whole bunch else, but not ownership. Okay, folks, let's do this. Let's come up with a return date schedule. I'll write an order, hopefully, that triggers the Orange the credit union to really get serious about thinking about this. Attorney Higgins-Shea or Attorney McNichol, probably more likely. Are you in touch with the lawyer for the bank?
The bank does not have a lawyer. The bank has a representative in asset management that I have certainly been communicating with, and I can certainly communicate with him again.
Yeah.
And I'm happy to reach out as well. Maybe, maybe dual efforts at this point. Push it along.
The bank, I understand, doesn't have in-house counsel. It's just a credit union. I got that. They must have a lawyer that they can consult with. Yeah. I would put the fear of potential liability in their soul if banks have souls.
Your Honor, if I might offer, Ms. McNichol or Ms. Higgins-Shea, if you have conversations with that and would like me to sit in on the conversations, please invite me. We can do it.
Thank you, Peter. Thank you.
Wonderful.
Be very, very interested in expressing what the federal law is about this, and then how this will affect them on the surrender. So,
hey, folks, one would think there is paperwork from the bankruptcy proceedings, if not a downright order from the bankruptcy trustee or judge, that makes this really clear, and that's what should be shared. And the Registry of Deeds should be updated, because I think the Velards don't own it anymore. But we're going to go by what the record says. Folks,
Your Honor, I will dig out every single piece of paper that was in the bankruptcy court case, and I will present it. If Ms. McNichol or Ms. Higgins-Shea want me to sit in on the conference with the credit union, I'd be more than happy to do that.
Yeah, I mean, I don't know if it's vital, but given that we might have insurance to cover, or the bank may get convinced otherwise. But if you think it's vital, of course, I'll leave it to you to go into bankruptcy proceedings and look for a clarification or an amendment to
I think that'd be good. But if Mr. Aubert is able to get the writer, I think that suggestion was a great suggestion. It would be kind of moot in that sense.
Yeah. All right, folks, let's talk about a schedule to get us back here and what has to happen between now and then. Typically we go 8 weeks out with 6 weeks between now and the next report. Does that work for everybody?
Yeah.
All right. So, Madam Clerk, if we can pick a day for a review, by then we're probably live in Greenfield. And I'm sorry, as we've done before, when we're live in Greenfield these days, it's a great facility. the Velards and Attorney Mulcahy can join through Zoom. Oh, Attorney Cunha, hi. We need a date about 8 weeks out, Greenfield Live.
Okay.
The April 8th, if that's available.
That is going to be, we're not going to have a judge in Greenfield, so I could do the following week. We have Judge Kane scheduled to be there, if it's okay.
What about the 22nd?
The 22nd.
Your Honor, I won't be in state on the 22nd.
Okay. What about the 29th?
I won't be in state.
Oh, I see. What about the...
Actually, I'm sorry. What about April 1st?
Yeah, as I was about to say.
This is
Works for me.
All right.
That works for me.
This is a joke.
April 1st, 9 a.m.
In Greenfield?
In Greenfield Live, unless we were instructed to go by Zoom, with a March 18th updated report.
Will do.
Why don't I entertain the following? I have no idea what the rider may cost, but for such a short period of time, I would imagine they charge you per month. Maybe they do it for the anticipated 6-month period or something. But what if we pick a number now that everyone can agree to? If it's below that, do it. Like $1,000. Bringing the total up to $105,000. Any opposition to that, folks?
No, Your Honor.
Okay. All right. Because if you can make that call and it's done today or Monday, that's a beautiful thing. If it's over 1,000 and you wish to be heard before our April 1st date, I would encourage that. Very quick hearing. To see if it's $20,000, that's a tough one.
I already texted my agent, Your Honor.
Okay, great. Anything else before we part? All right. Yes, Miss Velard Jr. Miss Velard, let me just give you an instruction. First instruction is you can unmute. Second instruction is if you're going to assert anything about why the Eagles should leave or what a pain in the ass they've been to you in your past, please don't address the court. Otherwise, you're free to speak.
All right, you already did that. I'm just putting it out there. As of now, they're done. There's no insurance that's coming. Not a penny is coming from the side. So that's all I want to say. Not a penny. So don't expect it. And
okay,
that's it.
Thank you so much. Thank you.
Oh, welcome.
All right, folks. We'll see ya. Thanks,
Thank
everybody.
you,
Good
Honor.
luck.
Thank you, Your Honor.
That's perfectly fine.
Thank you, Your Honor.
How much?